So I have a ton of slides and not a ton of time, so I'm going to go through some of this stuff pretty quickly. Have any of you heard of the public charge rule that is coming? So a few, right? So there's been a lot of news stories about this. It's going to go into effect next Tuesday. We're hoping that there will be a federal preliminary injunction. I was just checking my phone before I got up here, hoping that maybe I could be like surprised. It's not going to go into effect on Tuesday, but we're hoping that it won't go into effect. So this is going to affect a lot of folks that are immigrants that are, it's going to have a chilling effect on people taking advantage of services and certain public benefits. And there's been a lot of misinformation about it, and so a lot of folks that don't need to be scared about this are scared about this, and I think we'll have a lot of questions about this coming up. So my goal today is, well, one is not to make you an immigration expert, because that's impossible. I've been doing this for a while now, and I learn new stuff every day. It's an incredibly complex field with a lot of ins and outs, but it's to sort of give you an idea of some of the issues involved, and an idea about what this new public charge rule is and how it will affect the people that you all work with. So, my name is Josh Snowden. I work at the Immigrant Legal Center in Omaha, Nebraska. We are formerly Justice for Our Neighbors, Nebraska. A little bit about us: we're a 501c3 with a mission of creating welcoming communities and inclusive communities by providing high-quality legal services, education, and advocacy. All of our clients are at or below 150% of the federal poverty guidelines, and all of our services are 100% free, 100% pro bono. We just moved our offices to 42nd and Center in Omaha. Some of our programs, the Immigrant Focused Medical Legal Partnership, of which I'm a part of, so we partner with Children's Hospital, One World Health Center, and Nebraska Medicine to provide legal services, immigration-focused legal services to patients, a child and family team that does a number of cases, our rural community inclusion team. We have offices all over the state, from Scotts Bluff to Grand Island, Lexington, and a whole bunch more. And our domestic violence team that works with survivors of domestic violence and other forms of abuse. And we have some services in Iowa as well. So, in order to understand the public charge rule, it's necessary, and in order to understand who this will affect, it's necessary to understand some things about our immigration system, and just sort of a 10,000 feet view of immigration law in the United States. So I'm going to go through a bunch of stuff pretty quickly. And don't worry if you're like, I don't really understand what that means. This isn't intended to make you an expert. So it's a pretty simple system, as you can see. Not a lot of agencies involved. That's me trying to be funny. But there are a number of agencies involved. All three branches of government: the executive branch, all the agencies, so the Department of Justice, which administrates all the immigration courts, Department of Homeland Security, which administrates the different agencies such as ICE, CPB, USCIS, Department of State, which manages the overseas processes, and include even HHS, the Office of Refugee Resettlement. And of course, the legislative branch makes the laws, the statute that is the immigration laws, and then the federal judiciary as well has a role in reviewing cases and reviewing decisions by the Department of Justice. So I think it's necessary to understand sort of who is who, right? So we can kind of start with two buckets, right? Citizens and non-citizens, right? So citizens by birth in the United States. You can also become a citizen by a process called naturalization, where after you do certain things and are a legal permanent resident for a certain amount of time, you can apply to become a U.S. citizen. And also by these processes of acquisition and derivation, which has to do with children born outside the United States, but your parents do certain things, and a bunch of complicated rules that you can also derive citizenship that way. On the other hand, we have non-citizens. Right? And so we have legal permanent residents, commonly known as green card holders. So to become a citizen, this is always going to be a necessary step along the way to become a citizen, right? You can't go from nothing to citizen. You always are going to be a legal permanent resident for some period of time. We also have folks fleeing persecution, so refugees and asylees, right? Which Even though maybe if you're a refugee or asylee, you're not automatically a legal permanent resident, you still have to go through the process of applying to become a legal permanent resident. Folks here on temporary permission, so maybe you've heard of TPS, temporary protected status. Folks that are in countries where there is some kind of natural disaster or political upheaval that are allowed to remain in the United States, places like El Salvador, Libya, Liberia, Haiti, and some other ones. And those statuses are all being revoked in the last few years because the Department of State has to decide to renew that. And those are all being revoked, and there's a number of court cases right now which are challenging those revocations. Non-immigrants, which are folks that are here on a non-immigrant visa, so certain student visas, certain worker visas, and of course, undocumented folks. I just really want to make this point because I think there's a lot of misunderstood things about undocumented folks. There's sort of two main categories, right? People that entered without inspection, so people who, for lack of a better way to describe it, sort of crossed the border unlawfully, and people that did come on some kind of visa, some kind of lawful entry, but overstayed their period of stay, right? And it's about half and half, the numbers I've seen of who is who in the undocumented categories. If you are a visa overstay, your sort of future avenues for possible immigration relief are going to be a lot better because you'll trigger fewer grounds of inadmissibility. And most importantly, I think words do matter and that we should really shy away from using the term illegal or illegals. Being in the United States without immigration status is not a crime. You can't have a crime based on a status. A crime has to be based on an act. And being here without status is not illegal. I got a speeding ticket one time, and that's illegal, and I don't think you should call me an illegal, so I don't think you should call folks illegal. Okay, so some limited categories of immigration relief. How does one become a U.S. citizen? Diversity program and employment-based immigration, we don't really do a lot of that in my office. It's a very limited category. The sort of main two categories are family-based and humanitarian-based. And this public charge rule, which I'm going to talk about today, only applies to those folks that are family-based. So refugees, asylees, beneficiaries of U visas or T visas or special immigrant juveniles, this rule will not apply to them. I think that's really important to remember, right? This will not apply to refugees, asylees, and other beneficiaries of humanitarian forms of relief. Who it will apply to are these folks that are family-based. And I want to talk a little bit about the family-based system because I think it's important to understand. Oh, actually, before I talk about that, excuse me, I am going to go through some of these humanitarian statuses. So for asylum and refugees, right? Asylees and refugees are sort of conceptually the same, but procedurally different, right? Refugees are adjudicated and deemed to be refugees while outside the United States in a third country that's not their home country. It's a very long process that involves a number of years and years of waiting and sort of a degree of luck too to be able to get the status. A lot of people languish for a long time hoping to get the status. Asylees, on the other hand, enter the United States and apply for the status while within the United States. And what it involves, this goes back to a treaty from 1952 after World War II, when people said, well, that, it's pretty terrible what the world just went through with the Holocaust and folks that were trying to flee Germany and that were turned away. And so it kind of came together and created this sort of international body of law about to sort of try to create a legal framework to how folks can seek protection in other countries. So what you have to prove if you're claiming asylee or refugee status is that you've been a victim of some past persecution or you have a well-founded fear of future persecution on account of, it's the most important thing, race, religion, national origin, political opinion, or membership in a particular social group, right? So it's not enough that you've just been persecuted. You have to be persecuted because of something about you that relates to one of these 5 statuses, right? So this gets really difficult. I meet clients all the time that say, well, this terrible thing happened, they killed members of my family, and all this bad stuff or they did terrible stuff to me. And you really have to figure out a way to make this fit into one of these things. You know, was it based on one of these? Particular social group is sort of the most, is where you can sort of make fit these things in, right? So things like LGBTQ folks, or gender, for example. You'll notice gender isn't on here. In the past, before these last few years, there was some success of being able to argue things like Guatemalan women whose husband view them as property and can't leave their abusive husbands without threat of being murdered. So I guess the point is, it's difficult, right? Asylum is sort of difficult to prove and to win. And it gets more difficult as the years go by, as the sort of funnel gets shaved down, and down. All right, so another important category, which we do a lot of in my office, is U visas. So those are victims of certain qualifying crimes. Domestic abuse is the largest category that we see, and sexual assault. And if a person suffers substantial physical or mental abuse or harm, and they possess information involving the criminal activity, and they are helpful with law enforcement agencies in either investigating or prosecuting these crimes, right? So this is why, and sort of you think about this, the idea is we want folks to be able to report crimes and not be afraid of negative consequences because of their immigration status, or maybe because of how the police were back home. You know, I just this morning I had a consult with a woman that had a lot of awful things happen. Unfortunately, though, she never called the police because she was scared and was told by her abuser, if you call the police, they'll deport you, and if they deport you, I will murder you if you go back home. So those are difficult. It's a difficult consult to have, because if this person had made that phone call to the police, it would be a different story. The other problem with this status, I should mention, is there's only 10,000 of these visas available a year. So the wait line has gotten to be insane. So when I file these claims for folks, I always have to tell them, well, you could maybe expect this to be approved in 10 years with the way the wait line is right now. After 10 years, or after it is approved, then after 3 years of being in the United States, then you can apply for a green card. So it's a very long road. T visas are for victims of human trafficking. So you have to be a victim of some kind of severe form of trafficking, be that labor trafficking or sex trafficking. I think when we say human trafficking, a lot of people only think of sex trafficking, right? But labor trafficking as well is very, very common here in Nebraska, where they take someone, take someone's ability to leave, or sort of hold them prisoner, or withhold wages and things like this from folks. And they're folks that are exploited because of their immigration status. There's plenty of visas available in this category. The problem is, in the last 3 years, these have gotten extremely difficult to win when they used to not be difficult to win, to where they have about a 50% denial rate. So it's gotten, like everything in immigration, it's gotten more difficult. All right, so special immigrant juveniles, I do a lot of these kinds of cases. These are for folks that are under 21 and they're present in the United States, they're not married, and they have been abused, abandoned, or neglected by one or both parents. The trick is you have to go to a state court and get a state court order that says that they've been abused, abandoned, or neglected by one or both of their parents. So we do that through guardianships, through divorces, or through custodies, or through basically in family law kind of stuff. You have to be able to prove that reunification with one or both parents is not viable, and that return to the country of their last habitual residence is not in the best interest of the child. We've actually made, so these, like, judges used to really push back against this. We've made a lot of progress in Nebraska of sort of educating the state judiciary that this is something that they, one, have the power to do, and that two, is beneficial to the best interest of the child, which For minors, that's always what judges are supposed to be thinking of. Again, the problem with these are that the wait list has gotten very long. So if I file one of these today, I usually tell folks you can hope in maybe 4 to 5 years of this being approved, and then you can apply for a green card once it's approved. The other issue is that folks that are in immigration court, which I represent a lot of folks in immigration court that we've applied for the status, it gets more and more difficult to convince the judge to continue the hearings because these take so long, and the judges are like, well, what are we doing here? Like, every time you ask me for a continuance, so it gets difficult. No, it doesn't. There was a federal court case about that, and they came to a settlement that says that as long as it was filed before age 21, that you are sort of frozen or you're sort of grandfathered in as long as it's filed. The tricky thing is really you have to be in Nebraska, the age of majority is 19. So really you have to be under the age of 19 to be able to get into state court to get a judge to enter these findings. But then you have until 21 to file with the federal government. All right, so I want to talk about family-based immigration, and if I could leave you with one thing, it would be to dispel this notion of, quote, chain migration, which we hear a lot about, and you hear people say, well, and then they bring in the cousins and the uncles and the aunts and the whole family comes. That's just not true and not how the system works at all, and I hope to be able to demonstrate that. So basically you have 2 categories. You have immediate relatives and these preference-based categories, right? So if you are the spouse, parent, or son or daughter of a US citizen, you are an immediate relative. There's no wait time for your visa. You are able to apply and the visa is immediately available, right? So if I marry a person from Canada or something like that, and I can immediately apply to have her be able to come over and get a visa and enter the United States. There's also these preference categories, which are, there's 4 categories. So you have unmarried sons and daughters of US citizens. So if you're over the age of 21, not a child, and you're not married, you're in the sort of first category. If you are the son, child, or unmarried son or daughter of an LPR, you're in the second category. In the third category, married sons and daughters of US citizens. And finally, siblings of US citizens. So that's it. That's the only family-based. You can't petition for cousins or uncles or any of this stuff, right? It's very narrow categories. Now that seems all right on its face, like we have a pretty good system. Well, the problem is that there's not a lot of visas available. Every month, the Department of State publishes this thing called a visa bulletin, and this shows when they are adjudicating cases based on when they're filed. So if you look, we have sort of China, India, Mexico, Philippines, and everybody else. So China, India, Mexico, Philippines are the 4 countries with the highest rate of immigration to the United States, so they get their own categories, and then you get everybody else over there on the far left. So let's imagine that I have a brother in Mexico and I want to petition, and I'm a US citizen, I want to petition for my brother in Mexico to come to the United States. So I go to see my immigration attorney and I say, I'd like to do this. And the immigration attorney would say, okay, well, yeah, that is allowed, that a citizen can petition for their brother or sister. Let's see here, let's look down there, F4 down there at the bottom. In Mexico, it says 01 January 97. Right, so that means that they are currently adjudicating cases from January 1st, 1997, 22 years ago. So you might say, oh, 20 years is a long time to wait, well, then I would say, well, it's not going to be 20 years because these numbers don't move sort of day for day, right? It moves about 1 or 2 months a year. So people have done studies to try to figure out, like, if you applied today, how long would it take? If you were to apply today, you would wait 162 years to have your visa be available, right? So unless you have a secret to aging that I don't have yet, that visa sort of is a legal fiction, right? It doesn't really exist. I mean, it exists, but it's never going to happen. Of course, the laws could change and more visas could become available, but as it stands today, it's just not possible for folks from Mexico to petition for their brother or sister. So it's an extremely, it's sort of a broken system, and in all the other categories as well, right, for Mexico. So like married adult children is 106 years. There's just too many, not enough visas available. And I'll meet folks sometimes that are like, hey, my sister petitioned for me in 1998. And I'm like, great, you're one of like the magic ones that 21 years ago, you've been waiting for 21 years. And it's those are really awesome when those cases walk into my office. All right, so even if you have these paths to immigration relief, there's a whole nother set of roadblocks that you have to think about, these are called the grounds of inadmissibility. So maybe you can qualify for something, but there's a problem. For example, there's health-related grounds. So the most common would be like TB, tuberculosis. Criminal-related grounds, so you've committed certain crimes, what we call a crime involving moral turpitude, which no one really can agree on what that means. National security grounds, so if there's some sort of a link to maybe some group that we don't like, or there's maybe like a terrorist group. The public charge, which I'm going to talk about in depth here, and how that's all going to change in the next few days. Certain fraud or immigration violations. So the big one here is false claim to U.S. citizenship. And the trap that people fall into is if you're undocumented and you need a job and you go to fill out that I-9 and you check that box that says U.S. citizen, you have really made a big mistake, because now you are permanently barred from ever having an immigrant visa. And I see this all the time. It's a really harsh law that needs some kind of waiver built into it, where people can maybe get a waiver if they've no criminal history, was only for the purpose of work, wasn't to vote illegally or anything like that. It was just to be able to put food on the table. And then of course prior removals or unlawful presence in the United States. So there's all of these things that can block you from being able to benefit from some immigration law. You can get barred for 3 years, 10 years, 25 years, or a permanent bar, depending on what the facts are. And for some of these, there is waivers available, right? So for unlawful presence, for example, if you have a U.S. citizen spouse or parent, and you can prove that being separated from them is going to cause exceptional hardship to them, you can apply for a waiver. What exceptional hardship means is it's more than like being separated, right? Even though I would think is pretty exceptional to be separated from your spouse. That's like, no, my spouse has cancer or something, and I need to be here to be able to care for them, or my spouse is clinically depressed, and if we're separated, it's going to be really bad. So you have to really provide a lot of evidence to show that it's going to be sort of more than just the normal hardship of being separated from someone. All right, so the public charge. This was leaked about over a year ago. And they leaked this really, really harsh version of this that freaked everyone out, to put it bluntly. It was like, oh my, this is really what they're doing. And it was basically said, anyone, if your children, like U.S. citizen children, if they've ever used Medicaid, or it was like things like Head Start or free and reduced lunches, you're going to be a public charge and you're sort of out of luck. Well, that's not what happened, right? I really think that there was an effort to leak the most harshest rule just to sort of scare people and to create a really chilling effect for folks, and just basically to make people's lives unpleasant, so that just to be awful, basically. So The rule then was actually came out, was released in, I think it was October of last year. There was a 60-day notice and comment period. We led a big campaign, particularly with health centers, to go comment on the regulation website about how this was going to be terrible for patients and their families. And then they took a long time to review all those comments, and they came out with this rule in August, 940 pages long. It's fascinating reading. That was supposed to be a joke. That's pretty good. It's not fascinating reading. It's really dry and terrible. And so now it's going to go into effect on October 15th, barring, of course, a federal court stopping it. There is an enormous amount of lawsuits about this right now, challenging the legality of it. And will it happen? Like I don't know. We will see, but I'm not super optimistic. All right, so what is this? What is this public charge? So, well, first of all, let's talk a little bit about immigrants and public benefits. In general, most immigrants don't qualify for public benefits. There was this law in 1996, which made it much more difficult and created these categories of qualified and non-qualified folks, or of non-citizens. So qualified categories are legal permanent residents that have been a legal permanent resident for at least 5 years. So that 5-year thing is very important. Refugees and persons granted asylum or withholding of removal. And then, you get Cuban and Haitian entrants. Those Cuban and Haitians have sort of some special laws, and certain abused immigrants and their children, and then certain victims of trafficking. So a pretty narrow category. Now in other states, and more like states like California, they make some state benefits a little bit more available, right? In Nebraska, not so much, but in other states, it's a little more easier for folks that aren't qualified to access benefits. So when thinking about this public charge rule, it's less about benefits, particularly here in Nebraska, because you're just not going to be qualified for most things, and more about income and employment, which I'll get into. Not qualified immigrants is basically everybody else. And of course, there's some exceptions to these restrictions. So emergency Medicaid, certain treatments of communicable diseases, 599 CHIP, WIC. Excuse me, so undocumented folks or mothers, their children are, they can qualify for WIC, the idea being that it's going to benefit the citizen child that is born and not necessarily the mother. School breakfast and lunch programs, and certain other safety net services, like federally qualified health centers. Okay, so this public charge stuff. So I think that you might see certain folks being afraid to attend medical appointments, or disenrolling from a WIC, or disenrolling their children from Medicaid and other programs because they've seen these stories. There was a lot of really awful journalism that went down when this rule was first leaked, and like headlines like, they're going to take away people's citizenship for using Medicaid. No, that's not going to happen. That's not on the table. This rule only applies to when you're applying to become an LPR, right? It's not naturalization, although there is some things about naturalization. It's not that quite, like most things, it's not that black or white, right? Like, yeah, it kind of plays into naturalization, but for 95% of folks, it really has nothing to do with that. So as we said, it's a ground of admissibility. So it's not, I think this is really important, a ground of deportability. So you won't get deported if you are based on this public charge rule. It's only when you're trying to get status, as opposed to just maybe you don't have status and they will and you can get deported. So it's, if you are an LPR, or if people are LPRs, they're pretty safe, right, and shouldn't have to worry about this rule. Public charge is it basically refers to anyone who is likely to become primarily dependent on the government for their livelihood, right? And it's this totality of the circumstances test. So you look at a person's age, health, family status, financial status, education and skills. And before, there was something called the affidavit of support. We still have it, But it used to be that if you had this affidavit of support, you basically overcame this thing, this test. And that's, maybe you've heard of people, of sponsors, right? When someone sponsors someone for their green card, that's what this is, right? So someone would sponsor you, they have a certain level of income that you show through taxes and stuff like this, and you do all this paperwork, and you're good, right? So now, that's no longer the case. Now that's just gonna be one minor factor along with all this other stuff. It used to be that the only things that triggered problems with the public charge was cash assistance for income, maintenance, or institutionalization for long-term care at the government's expense, right? So pretty rare things. One thing is that, and I didn't really get into this, but there's sort of two places where this can happen. This can happen within the United States, if you're doing what's called adjustment of status, where you're applying to become a legal resident here, or it can also happen outside the United States if you're applying through a U.S. consulate abroad, right? And there are different agencies and different set of regulations that you have to look at. From what I understand, the Department of State will be changing their regulations to come in line with these regulations, but we just don't know yet. Okay, so the new definition, what does it mean? It's going to, one of the things it's going to do is it's going to expand what is a public benefit, all right? And it's going to be now include non-emergency Medicaid, SNAP, Medicare, Part D, and some forms of housing assistance such as Section 8 housing or rental vouchers and things like this. What it is not, and we've gotten lots of questions at our office about this, for example, disaster relief. So like folks out in western Nebraska, maybe there's some federal money available for folks that have had their houses destroyed because of the flooding that happened out there. Disaster relief does not count as a public benefit. Emergency medical assistance does not count. If something is entirely a state or local or tribal program, other than cash assistance, it doesn't count. And most importantly, benefits received by family members. So if someone has U.S. citizen children, right, and they're maybe undocumented, and their citizen children is receiving SNAP or Medicaid, or that will not affect them. That will not be considered a public benefit. Which beforehand we really thought that was going to be a problem. Things like WIC and Earned Income Tax Credit, also not considered a public benefit. So, like I just said, U.S. citizens' children's, it won't prejudice folks. Okay, so most importantly though is going to be income, right? What this is, I would argue, what this is really about is we want wealthy immigrants. Not even wealthy, but like well-to-do, right? So it will require that you earn at least 125% of the federal poverty guidelines, which will be, if you don't make that, it's going to be a heavily negative factor. Now, if you make more than 250%, that's going to be a heavily weighted positive factor. And like I've said, who does this apply to? It applies when applying for lawful permanent residency or when seeking to enter the United States with a visa. It does not apply to refugees, Violence Against Women Act, self-petitioners, SIJ applications, or T visas. Does not apply to citizenship naturalization. All right, so as I've said, the old rule really focused on the affidavit of support about the citizen or LPR sponsor. The new rule is going to focus more on those factors of age, health, family status, financial status, education, skills. And it used to be that it had this sort of loose definition of applied to those who are likely to become primarily dependent upon a designated list of federal and state programs. Now what it's going to do is look at a 36-month period, and if you received any public benefit for an aggregate of 12 months, then that's going to be very heavily negative factor. And of course, it expanded the list of services or the list of things that are considered public benefits. So let's kind of delve into this a little bit. Who will be considered, or what factors will be considered in determining who this will apply to. It's still a totality of the circumstances test. It's not required to receive public benefits to have this rule apply to you and negatively impact you, but it certainly is a factor. And it'll still focus on those same factors. There's going to be a new form, the I-944, which the draft was just released today. It is 18 pages long, and it is a monster. People are banging their heads on their desks right today. I'm part of a Facebook group of immigration attorneys. There's a lot of swear words on the Facebook group today. It's like, are you kidding me? Like, it's going to make everyone's fees go up. It's going to require things like run a credit report on yourself and be able to account for any mortgages you have ever had, or any sort of negative thing in the past is all going to be explained away. It is going to be pretty crazy. Okay, so how will age, what factor will age play into it? Well, the central question to all of this is how will it affect your ability to work, right? So if you're under the age of 18, it's not gonna really affect you. But if you're over the age of 61, it's not really gonna affect you. Instead, if you're not between 18 and 61, it's gonna look at who is sort of responsible for your care, right? So I'm actually I'm doing a case right now in immigration court with a 70-year-old woman who has cancer and whose daughter is petitioning for her. And so what we have to do is not look at the 70-year-old woman, because she's retired, and instead it's all about her daughter's finances, right? And I hate to be like, so let's delve into your financial history and get all this stuff out, but it's unfortunately what we have to do. How will health and health insurance be evaluated? So the central question that this rule asks is, does the intending immigrant have a medical condition that is likely to require extensive medical treatment or institutionalization, or that will interfere with the alien's ability to provide and care for himself or herself, or to attend school or work? So basically, it's, can you make money, right? And will you have some sort of a health, either a health problem that will either keep you from making money, or that's going to cost a lot of money, right? And you're going to have to show that either you have insurance, or that you have the sort of financial resources to be able to pay for that. Another thing too about the insurance, and I'll actually speak. Maybe you saw there's a new last Friday night. I was enjoying my Friday night. Look at my phone, and oh no, another thing happened. Now there's a new rule that was just announced on Friday night, that now they're going to require folks to have health insurance in order to enter the United States. And it will not count will be ACA subsidized insurance, right? It has to be unsubsidized insurance. It will count the catastrophic and the non-ACA compliant junk insurance that they've ran out this year. So it's going to be a huge boon for insurance companies, because immigration lawyers are going to have to counsel their clients before bringing over their husband or something like that from abroad. Like, well, you need to buy this junk insurance plan just so we can show that you have it, even though it's basically it's no good because the deductibles are so high and stuff. Okay, so family status. So the larger the family, the more income that you're going to have to prove, and there's a really complicated formula about who is in the household and who is who. That's going to be a headache for folks to figure out. And finally, or not finally, but how will financial status be analyzed? So we'll look at just your gross income, but also other assets such as real property, securities, things like that. But it'll also look at, as I mentioned, all of your liabilities. So mortgages, car loans, liens, credit card debt, right? Sort of like, I don't know if I would be able to immigrate to the United States right now because I have credit card debt and car loans to pay and a mortgage. It's going to be really tough. Things like bankruptcies or previous requests for immigration fee waivers are going to be counted against you, and of course, but if you make over 250% of the federal poverty guidelines, it's going to be heavily positive factor for you. Yes. So if this does go, if they've already started the process, like if they're already current, no, it's going to be like it's not going to be retroactive. So everyone's been really busy this week getting in all their last-second adjustment of status applications. But for those folks that have been waiting for 20 years, the process doesn't really start until you become current, right? So if you have like a petition filed, but you're going to become, next year you become current, that's when you start to go through the process. So unless you sort of, in the last month or so, have already started the process, yes, it will apply to you. And so employment, and you will have to show high school degrees or post-secondary education degrees. You'll have to prove equivalency of those degrees, which is super difficult. And then this, I think, is one of a really troubling thing is that English proficiency will be a heavily weighted positive factor under the theory that if you can't speak English, you're somehow unemployable. I disagree with that. I'm sure lots of other folks do too. And then there'll be a carve out for if you can prove that if there's a gap in your employment history and you can prove that you are taking care of kids at home or a sick family member or something like that, well, you'll get a break. So, once again, these are the 9 specific programs that are considered public benefits. SSI, TAMF, state or local general relief or general cash assistance, institutionalized long-term care, then also adding Medicaid, SNAP, Section 8 housing voucher programs, and rental assistance, and then just public housing. The categories are narrow, right? So it's we just had a question today. Somebody emailed me and said, hey, well, if someone goes to One World Health Center and they get like assistance from One World Health Center to help pay for because they're so low income that they can't pay for their services there, does that negatively affect them? And I can say very surely no, because the rule is very specific about what programs are considered public benefits. Okay, so what happens if a public charge finding is made? Well, at the government's discretion, they can offer you a bond to pay $8,200 to overcome this, right? And then you can get that back in 10 years if you don't become a public charge. I don't think with interest. It's not like a CD or something. So that seems pretty harsh, and that's also not something that will just be available. It has to be at the government's discretion, right? If they think like, oh, maybe you're almost good enough, but not quite, pay us some money and you'll be okay. You can always file an administrative appeal if you believe the finding is erroneous. And then what I'm really excited about is federal litigation. And as you know, there's already several lawsuits that we'll be finding out in the next few days what happens. Will they be successful? I don't know. I hope so, certainly. But I would caution that they did take a year to craft this rule and 940-page rule. So unlike a lot of things that have happened in the last few years, this wasn't sort of rushed out the door without maybe being thought through all the way. They've been working on this for a long time, and obviously with the goal of making it immune to legal challenge. So some sort of general messages for families. Generally, it will not affect those people who are already legal permanent residents or naturalized citizens. Not all immigrants are subject to the public charge tests. So refugees and all these other folks. It looks at the total, the sort of total picture of the person, not just public benefits. So I mean, because the sort of idea is, if you're low income enough to qualify for these public benefits, you're already probably going to have income problems without thinking about public benefits. And the best thing to do if you're unsure is to consult with a reputable immigration attorney about this. And I'll have up on the end the Nebraska Immigration Legal Assistance Hotline phone number that folks can call. Will LPR and green card holders be affected? Nope. How will the rule affect individuals with disabilities? Very negatively. Are education programs included? No. Are WIC benefits included? No. Will people be deported if they become a public charge? No, at least not yet. So there's the phone number for the, this is a hotline that connects a bunch of different nonprofits here in Nebraska for low-income folks that maybe are in need of immigration assistance. It's Spanish-English bilingual, but they also have access to a language line that they can basically do any language. So if folks have questions or maybe have questions about their immigration status, they can always call this number. And if there is a case, they can sort of filter people to an agency that can help them. There's some good websites. ProtectingImmigrantFamilies.org is the one I would highly recommend if you want more information. They have been on the forefront of this fight since this rule came out, and that website is chock full of great information and community resources and education resources in a multitude of languages, and they've done a really excellent job. Do you have any questions for me? Is the question about folks that came on their own? Absolutely. Like, in the majority of those cases that I do are what we call unaccompanied minors, right? The abuse, abandonment, and neglect doesn't have to happen in the United States, right? So, I was forced to drop out of school in the 3rd grade so I could work in the fields, and my father was an abusive alcoholic or something like this, and so I fled, walking from wherever, from Honduras to the border, and then presented myself at the border. That's absolutely a case those kind of cases. For SIJ, yes. You have to prove that there's some kind of neglect, abandonment, or abuse. Sure. So I mean, obviously, like, it can be anything. Sometimes they're really things like sexual abuse or something like that, or like my mom hung around with these bad men that did bad things to me, right? Or something like that. I've had cases like, what's that? So it's usually just through testimony and affidavits in the court hearing. If there's other corroborating documents, which we have had before too, like a death certificate from somebody or things like this. Or things like, or it can also be things like my father left when I was 2, and my mother was never around. I live with my grandma. My grandma's old now. I'm 15 years old. My parents abandoned me. And now all of the gangs are trying to recruit me because they prey on folks that don't have fathers and parents around to protect them. So I was in danger. So I left because I didn't want to join MS-13 or whatever. And I came to live with my uncle in Omaha, for example. Things like that.
So an oral documentation can be adequate.
Yes.
Legal aid.
Okay, so if they are, I forgot to mention when I was talking about that, those findings can also be made in juvenile court, right? Or they can be made really in any proceeding. So if it is like a custody proceeding with CBB and there's like a gal involved, a guardian ad litem involved, those findings can be made at that time, right? Or if they're like going to be like under the custody of the state, become a ward of the state or something like that. That can happen at that time. We have done some like CLEs and things like that with Child Protective Services and guardian ad litem offices to like make them aware of this for folks that are maybe undocumented that could benefit from this. Yeah.
Thank you, sir.
Yeah, thank you, everyone.